We are live.
Thank you, Connor. Hello, this is a convening of the Massachusetts Gaming Commission. I'm Jordan Maynard, and I'm serving as chair of the commission. Today is December 16th, 2024. It's approximately 11:04 a.m. A rare Monday meeting. We're holding this meeting virtually, so we will do a roll call. Good morning, Commissioner O'Brien.
Good morning, I'm here.
Good morning, Commissioner Hill.
Good morning, I'm here.
Good morning, Commissioner Skinner.
Morning.
And good morning, Commissioner Broder.
Good morning.
All right, meeting number 542. We're going to start with item number 2. And for that, I'm going to kick it over to Secretary Skinner.
Good morning again, Mr. Chairman. I move that the commission approve the minutes from the November 27th, 2023 and the January 11th, 2023 meetings that are included in our package, subject to any necessary corrections for typographical errors or other non-material matters.
Second.
Thank you. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Aye.
I think, yeah, these are, I think you mean you abstained, Commissioner Broder, correct?
Oh, what? Wait, which state are these?
Yeah, these are the,
These were all prior to your appointment.
Yep. Abstain. Thank you, Mr. Chairman.
no problem. And I vote yes. So 4-1 abstention. All right. With that, thank you, Secretary Skinner. Thank you, Judy, and the team, Autumn, and those that put those minutes together. We're now going to kick it over to Executive Director Dean Serpa for an administrative update.
Oh, yes. Good morning. Thank you, Chair Maynard, and good morning, commissioners. I do have 2 updates today. First, I guess I want to turn to, as you know, the racing season down at Plainridge ended right after Thanksgiving last month. And just to wrap that up, Director of Racing Alex Lightbaum was going to give us a brief summary of the activities from the season. I did hear from Alex. I want to make sure she's able to communicate with us. Alex, are you able to hear and communicate now? I just received a text that she was having some computer issues. Yeah.
So do we want to?
I don't see it. Yeah, I think what I'll do is I'll go to the second part of my update for us today, and hopefully Alex will be able to join us because she's got a lot of items on the agenda. So that being said, the other thing I wanted to make sure all the commissioners knew is that we have, I guess I would call it a bit of a changing of the guard happening next month in our intern in co-op program, the Northeastern University co-op program. So as you might remember, we had 2 6-month co-ops with us over the summer and this fall. We had Diana Zhao working with responsible gaming and Camilla Mazon working in finance. So both Diana and Camilla are going back to school next semester. And we definitely want to thank them for their work while they were here. They were great additions to our team. And I think Mark and maybe John Scully have a few comments they want to pass along as well. Mark, you go first.
Sure. Good morning, Chair Maynard. Good morning, commissioners. I had the privilege of working with Diana and Camila over the last 6 months, most closely with Diana. So I would love to just say a few words about as she wraps up her time with the Gaming Commission. I think probably most of us on this meeting have been interns or had intern experiences. And to be on the other side and provide supervision for an intern, you know that it's intended to be a learning experience. And I really hope that is the case for both Camila and Diana. And I would like to say that it was also a beneficial experience for the Gaming Commission and their contributions. And so I mean, Camila touched a lot of different areas, or I'm sorry, Diana touched a lot of different areas of the research and responsible gaming division. She worked on predictive models for AI that completely aligned with what her focus of study has been at Northeastern University. She worked closely with Bonnie on creating research snapshots for reports that were released. When Long was gone earlier this fall, she pitched in and she managed the voluntary self-exclusion program, looking for people that were coming in and making sure that they were added to the list and removing people that were coming off. She worked with the Youth Sports Betting Safety Initiative and created a literature review that was then in turn used for the benefit of the committee, but also as a document as part of a procurement that the Attorney General Office released earlier this year. This is the type of intern experience that I think clearly was an asset to the Gaming Commission. And I hope, Diana, for your sake, this is something that you can take with you and inform what your next steps are as you enter your last semester at Northeastern University. So thank you so much, Diana.
Thank you so much, Mark. I'm really grateful for this opportunity to have worked with at MGC and contribute to such meaningful projects. Yeah, thank you.
Thank you.
And I think John has a
Mr.
few words.
Mr. Chairman,
Yes.
Diana worked right outside of my office, so I got to see her quite a bit. And I can't tell you how much enthusiasm she brought to this job and this internship, let me be clear. She was a great addition to the MGC family over the last 6 months. And Diana, you're going to be missed by all of us. And we thank you. And Camila, God bless you for having to put up with me coming down and talking about my 80s music and all that I brought to your little department. You two were a great addition, and from what I've been told by the staff down there, you're going to be missed considerably too. There wasn't one person in that department that didn't love having you on board, and you're going to be missed too. So in terms of success, the internship program, and you two were one of the first ever, I believe, to join us as interns in our new intern program. We couldn't have asked for two better people. So congratulations. We're going to miss you, and good luck in all your future endeavors.
Thank you so much. I really appreciate the kind words. Thank you.
Commissioner Hill, Judy Young was the very first intern at the Massachusetts Gaming Commission several years ago. So I want to correct the record for that.
Glad you did that, Mark. I was about to do that at the end.
Before my
first
time,
success
and-
story,
and-
right?
And by all means, correct it.
I want to make sure that Commissioner Bright, I see you're off, but I didn't know.
I didn't know if John wanted to go first.
I didn't know if John
Camilla?
went ahead. I didn't know if Commissioner Hill jumped the.
Guess I don't mind jumping in, going first, and we can save the best for last. Both Diana and Camila have been a joy to work with. I prepared some words for Camila, so I'd like to go over those real quick. Camila joined the finance team on July 16th. She came over to MGC as a Northeastern Co-op intern and immediately became an integral part of our team by assisting with our accounts payable, accounts receivable, as well as our procurement activities. She has been extremely instrumental in helping me to decrease my backlog of documenting and cleaning up our procurement files. Furthermore, she's helped me with interdepartmental service agreements, contracts, grants, and purchase orders. And she's helped with pulling and analyzing any related data to these agreements as needed, which has been a big help. She has spent roughly the last 6 months being nothing short of an excellent representative of both the Northeastern Co-op program and the MGC finance team. She has participated in the MGC team meetings at all levels, from the all-staff meetings to the MGC finance team meetings, to the weekly accounts payable reviews, to the monthly budget meetings with each division, to any related procurement meetings with each division. On top of all of that, she always has an amazing attitude and comes in ready to work, and is always looking for additional ways she can help our team. We will certainly miss her and wish her nothing but the best of luck in completing her studies. We would love to see her continue in her accounting and finance role.
Thank you,
Thank
John. Commissioner O'Brien?
So I did not have as much of an opportunity to see Diana as I did Camilla, given my role as treasurer. Both of you, we said this when you guys came on, Commissioner Chair Maynard and I were trying, for years to get interns back in here. Very, very happy that you guys were the next wave to come in. You've both done great work. And I will say, as someone who used to do this a lot in other agencies, it was a pipeline for hiring. So for what it's worth, Judy Young could be example number one of an early intern who's back here now. So, keep in touch and good luck as you go back to Northeastern to finish up.
Thank you so much. I would like to say, I really appreciate my opportunity here at the MGC. It's been a great experience for my personal growth, but as well as my career. So I will miss all of you guys, and thank you for the opportunity. It's been a blast.
Commissioners, anything else to add? Thank you. I'll just say I've had the opportunity to work and meet you both. I know that you're planning on going to lunch on Friday, and I did let you know, and so I'll say it publicly. Director Vanderlinden and John Scully, you should make it hurt on them. Wherever you ask to go and whatever you order, make sure that you make it hurt, because I understand they're paying for it. So, and we would love to see you guys back, and anything we can do, recommendations, anything we can do to help you, let us know. We're happy to do so, and we're very proud of the co-op and intern program here at the MGC, and happy Commissioner O'Brien and I were able to lean in on the organization enough to get it going. So thank you, Commissioner O'Brien, too.
Okay, if I can, Chair Maynard?
Absolutely.
I just want to, I'll say thank you to Diana and Camilla as well. And commissioners, I don't want you to worry. I just, because I want you to know, we actually have new interns starting with us next semester. We have Jaden Nelson O'Rourke, who is part of the Northeastern Co-op program. He'll be working with Joe, Lily, and Mary in community affairs. And we have a postgraduate intern, Adam Lepore, who is from WPI, and he will be working with the executive office and along with the commissioners. So don't worry, we're in good hands. I also am a big fan of the Northeastern program, and I'm glad we've been able to take advantage of it this past semester. Mr. Chair, with that being said, I've been informed that Dr. Lightbaum is back with us and ready to move forward with the racing update, so I would turn it over to her for that. Dr. Lightbaum, go right ahead.
Thank you, and I apologize for having computer difficulties. Thanks to Grace, the old go out and try coming back in worked, so despite everything else. We had a successful meet this year at Plain Ridge. One of the things that was down a little bit was our adverse drug findings. We had 18 last year. It was down to 13 this year. We always, appreciate when the numbers go down. And a lot of those were from the therapeutic medication list, where they're medications that are allowed in horses that are race horses, but not at over certain levels. So they were over those levels. Our rulings were also down a little bit, from 153 the year before to 137. The judges were very busy this year. Interestingly enough, we had 7 appeals of judges' decisions. In a usual year, we may only have 1 or 2. So we kept the legal team very busy, and I thanks to them, multiple people on that team assisted on the different cases. 2 of those were withdrawn. 2, the motions to dismiss were allowed. 1 was filed a year too late, so it was denied. And then we had 2 that did progress to the hearing officer stage, and we're waiting to hear back on those. This year we had 2 of our veterinary assistants get into veterinary school. As you know, it's very hard to get into it. I think the school accepted maybe 5% of the applicants, and they're both doing well. it's Sydney Scher, who was with us for 2 years, and Emily Averill, who was with us for 3 years. They're both intending to come back again and work for us next summer, but we'll see. They may end up with other options. But anyway, again, the people, our veterinary assistants, are a wide variety of folks. Some of them, it's their primary job. Some of it's a second job. That, you know, a lot of them are veterinary assistants at vet hospitals. And we also get a fair amount that are in college and applying to veterinary school. So it's almost like a paid internship to them. So just a shout out to them, because it is a very challenging and difficult program. And that concludes my update for right now.
Thank you, Dr. Lightbound. Commissioners, any questions for Dr. Lightbound? All right. ED Serpa, anything to add? All right.
I don't, Mr. Chair, that's my update for today, or our update for today.
That was a good update. So we appreciated that. All right, we're going to go to the next item on the agenda, which is legislative update. For that, we'll turn to Commissioner Hill.
Thank you, Mr. Chairman, and today we have nothing to report.
That was a quick update. All right. So we will turn it to the next issue, and for that, we're going to go to Councilor Grossman. Good morning, Councilor Grossman. Who froze up, I have to say. As soon as we called him. Now we got you, Todd.
If you were talking to me, I apologize. I seem to be having connection issues, but I think I'm back.
You're free to go.
Great. Well, good morning, Mr. Chair, commissioners, and all who are joining us here today. This matter is before the commission to interpret a very narrow issue pertaining to the application of a provision of Chapter 23K to a specific set of facts. The issue revolves around language in the institutional investor section of the law and whether particular activity runs afoul of that provision. This particular matter involves a former institutional investor to Penn Entertainment by the name of HG Vora Capital Management, LLC. HG Vora has requested that it be permitted to take certain action known as submitting advance notice of its nomination of members to Penn's board of directors. Of course, Penn is the parent company to the Category 2 gaming license holder operating Plain Ridge Park Casino, which also happens to hold a sports wagering license. And as far as the presentation today goes, I plan to offer a few more thoughts for you just to help calibrate this issue for review. Then we'll hear from HG Vora, which is represented by counsel here today. Then we can offer Penn an opportunity to comment, and they are present here today as well. And then we can also hear from the IEB, which is also represented on the call today. At that point,
Todd, you're going to have to repeat that last piece. We got the introductions through each of the parties that were here. We lost you from there.
all their investigation. And
Todd, you may want to go off camera and just do audio only, because we lost you after you talked about the parties who are here today.
Yep. Oh, you did? Okay.
We lost everything after that.
I'm not sure if you can hear me now.
We can now.
Okay. Here, well, I'll talk faster just to try to get through what I was going to say. After the party, let's see. Okay, so I was just going to go through a few matters just to help calibrate this and tee it up for you, and then we'll turn it over to all the parties to present their positions for your consideration. I was just saying, though, that you'll recall that under our regulations, and that's section 116.07 sub 2. One is permitted as a qualifier to perform duties and exercise powers related to their position while the investigation and final suitability determinations are pending, following the submission of the completed new qualifier application forms. This particular matter is unique in that, I'm sorry, I'm just getting, okay. This particular matter is unique in that the new qualifier here, HG Vora, was previously an institutional investor via an approval issued by the IEB in 2016. That institutional investor designation permits an entity to essentially hold over 5% interest in a gaming company, but not more than 15% without having to submit the familiar qualifier approval application and ultimately be deemed suitable. And they do that upon an agreement that it will hold the interest in the company for investment purposes only, and that it does not have any intention to influence or affect the affairs or operations of the company. If the institutional investor intends to influence or affect the affairs or operation of the company, then the law requires it to provide notice to the commission and refrain from taking any action that may influence or affect the affairs of the company. This is described in section 14C of chapter 23K, which is included, it's in page 43 of the commission packet that you have before you. For reference purposes, the same provision is outlined in our regulations as well. That's section 116.03 sub 4. So I thought it would be helpful just before we turn this over to the players to take a look at the provision of the law that will govern this particular review. So again, that's section 14C of chapter 23K. It's on page 43 of the packet. I'll just read through it real quick, just the pertinent section. And it says that an institutional investor granted a waiver which subsequently determines to influence or affect the affairs or operations of the applicant company or holding intermediary or subsidiary company of the applicant company shall provide not less than 30 days notice to the commission of such intent, and the commission shall ensure that the institutional investor meets the qualifications for licensure under said sections 12 and 16 before the institutional investor may take an action that may influence or affect the affairs of the applicant company or holding intermediary or subsidiary company of the applicant company. So with that, it's important to recall that the narrow issue before you today is whether the submission to Penn of advanced notice by HG Vora of candidates for consideration as members of the board of directors of Penn is an action that may influence or affect the affairs of the company, or as HG Vora has advanced, whether it's more of an administrative action designed to preserve its future rights. And so while HG Vora has asserted that the action should be permitted, the IEB has taken the position that it should not be. And one final note, if the commission is inclined to allow such action by HG Vora, it could also attach conditions or restrictions to ensure that such approval is narrow to these set of facts and circumstances. And again, I apologize for my connection. I hope you're able to hear most of what I just said. Happy to take any questions as to the governing law or the construct, but otherwise, Mr. Chair and Commissioners, I thought it might be helpful to hear from each of the parties before we move into a discussion about this matter. So, Mr. Chair, if I may, I'd ask, beginning with HG Vora, represented by Attorney Nozel, just to introduce yourself and your colleagues, and then you can go from there. Good morning.
Good morning. Thank you, Todd. Good morning, Chair. Good morning, members of the Commission. I'm Jed Nozel. I serve as outside counsel to HG Vora Capital Management. I'm joined today by Mandy Lamb, who's the general counsel of HG Vora Capital Management, as well as Jeff Katz, who's a partner in the law firm of Ropes & Gray here in Boston. And first, good morning. We do want to thank you for your time today. And as Todd explained, we recognize this isn't a typical issue that comes before the commission. As covered in our November 19th, 2024 letter, that's also part of your packet. And as Todd explains, HG Vora is before you today to request that the commission exercise its discretion in interpreting the Gaming Act's provisions for institutional investors that are subsequently subject to licensure to permit HG Vora to make a limited procedural step in early 2025 to preserve its eligibility to participate in Penn's board nomination process at a later date in 2025, and importantly, only after HG Vora is licensed at that time. So what does this practically mean? HG Vora would like to submit paperwork in compliance with Penn's bylaws. This paperwork would include the names and biographical information of suggested potential candidates to serve on Penn's board. The contents and timing of this paperwork are solely dictated by Penn. Throughout our presentation today, you'll hear us refer to this paperwork as advance notice or as advance notice paperwork. And as we're going to discuss in more detail, we believe the request to submit this paperwork is consistent with the Gaming Act. It allows HG Vora's licensure review to continue in the ordinary course. It preserves HG Vora's future rights as a shareholder. It's consistent with Penn's shareholder engagement policy, and it avoids inequities between similarly situated shareholders. Before we get into a little more detail on that, I just want to give you a quick overview of the presentation that you're going to hear today. First, Mandy Lamb is going to introduce you to the firm, HG Vora, and provide some background on its interaction and engagement with the IEB over the last year. And then she's going to describe our request in a little bit more detail. Jeff Katz will then summarize certain requirements imposed by Penn on its shareholders and why they're relevant in this case. We'll then turn to the statute and the commission's discretion under the statute. And then finally, we're going to underscore why we think our request, this narrow request, meets several different objectives that are important to the parties involved as well as the commission. And with that, I'm going to turn it over to Mandy Lamb. Of course, Mr. Chair, members of the commission, unless you have any initial questions for us.
Commissioners, anything for Jed? Attorney Nozel, I think we're good.
Thanks. Andy?
Thank you, Jed. First, I'd like to start off by saying on behalf of HG Vora, I'd like to thank the chair as well as the commissioners for their time today. I also wanted to note that we very much appreciate the time and attention of staff from the IEB and the General Counsel's office throughout this year, and especially in recent months. This is a matter that appears to be without precedent in Massachusetts, as well as in all the other states where we've been engaged with gaming regulators, which is about half of the country. My firm, HG Vora Capital Management, is an investment advisor registered with and regulated by the U.S. Securities and Exchange Commission. We were founded over 15 years ago in 2009 by our portfolio manager, Parag Vora. We're based in New York with nearly 40 employees. The firm provides asset management and advisory services to a broad range of investors, among them including institutional investors, such as endowments, foundations, pensions, as well as private charitable organizations. And on behalf of its clients, the firm owns approximately 9.5% of the voting common stock of Penn Entertainment. I think it would be helpful to provide a very brief history of HG Vora's interaction and engagement with the commission. And it starts with 8 years ago, as Todd had mentioned, in 2016, when the commission at that time had granted the firm an institutional investor waiver regarding its ownership in Penn. And that waiver expressly preserved HG Vora's right to vote its shares in Penn. And when you fast forward to 7 to 8 years later, in mid-January 24, which is nearly a year ago, the IEB had reached a determination that the firm was no longer compliant with the 2016 waiver. And as a result of that, the firm's status as an institutional investor was forfeited. And the firm was also required to file an application for licensure within 30 days. So that takes us to the licensing process specifically in Massachusetts. And within a week, on January 25th, the firm had filed its application with the IEB. And following that, in early February, the IEB had determined that additional applications were required. And I believe we responded promptly to those requests, filing all the additional applications that were requested by early March. And that we were pleased that in May, the IEB was able to deem all the applications complete. I think that that takes us to why we're in front of the commissioners here today. And so when the IEB determined in January 2024 that our firm's 2016 waiver was forfeited and that the firm would have to file license applications, it also instructed the firm that it was not permitted to submit advance notice to Penn, meaning the paperwork that Jed described earlier, relating to suggested board nominees. What this meant was HG Vora could not preserve its eligibility to participate in Penn's director nomination process. Several months later, at Penn's annual shareholders meeting in June 2024, in the same way as other shareholders are otherwise entitled to do. So I'd like to take just a very brief moment to emphasize to the commission that our firm respects the analysis as well as the position that the IEB took at the time, and that's in January 2024. And we sincerely hope that that's reflected by our responsiveness to IEB's requests, both in terms of substance as well as in the timeliness of our responses. And I'd like to say that as a result of recent discussions with the IEB staff and General Counsel's office, we submitted a revised request to the commissioners for relief last month. And we hope that this revised request is viewed as both sensitive to, as well as responsive to the concerns that they raised with us. So the request before the commissioners is very specific and it's very narrow. And what we're asking the commission to do is to exercise its discretion to permit HG Vora to take the limited procedural step of submitting an advance notice to Penn. Importantly, with two conditions. First, that the IEB determines that there's a reasonable expectation that the licensure review process will be completed in Q1 of next year. And second, we would agree to certain additional requirements and limitations that would help ensure that the status quo with Penn is otherwise maintained. So the key benefits of this are twofold. The IEB and the commission's review and determination processes would be able to continue in the ordinary course without disruption. And the risk of potentially creating unhelpful precedent for the IEB or the commission is limited or non-existent. So significantly, the present facts and circumstances, we believe, are materially and meaningfully different from the landscape nearly a year ago when the IEB first made its determination that the firm couldn't take this procedural step. At that time, in January 2024, the IEB had shared with us that it couldn't complete licensure of our firm in 4 to 5 months' time, meaning that it couldn't do so in time for Penn's annual meeting of shareholders in June 2024, and therefore viewed the issue as moot. Today, the issue of whether the firm can or should be permitted to submit the paperwork for Penn's annual meeting to be held likely in June 2025 is not moot. We were not a license applicant then, but we are today. Our applications were submitted nearly a year ago and deemed complete in May. But most importantly, we also understand from IEB that there is a reasonable expectation that the licensure review process for HG Vora will be completed in Q1 2025. In fact, the IEB plans to interview the firm as a license applicant 1 week from today on December 23rd. And of course, we're incredibly appreciative of the staff's efforts on this, especially leading into the holidays. I think at this time, I'd like to ask Jeff Katz from Ropes & Gray, Corporate Counsel at HG Vora, to explain what we mean by this advance notice or procedural step, and also to explain how the proposed conditions accompanying this request provide what we believe are the appropriate safeguards against conduct that may be considered to actually influence or affect the affairs or operations of Penn, all while our firm's license application is still pending before the commission. Thank you.
Thank you, Mandy. And to Chair Maynard and the commissioners, thank you for your time. And to the interns, congratulations. As Mandy said, I will be talking about this procedural step in the context of Penn's board nomination process. So Penn, like all public companies, regularly engages with its shareholders. All public companies also afford shareholders the opportunity to recommend candidates to serve on the company's board. But for a shareholder to exercise this right, that is, to nominate a director candidate for election by its fellow shareholders, companies impose strict requirements that the shareholders must follow. We believe it's important to understand Penn's requirements as a set of prerequisites that a shareholder must satisfy if it wants just to be eligible to participate in the company's board nomination process. These requirements are set by Penn and published by Penn. They're in Penn's bylaws and its proxy materials that it files with the SEC. And while all the conditions I'm about to discuss are prerequisites to nominating a director candidate at the annual meeting, each is independent of the other. So satisfying any one of them, or all of them for that matter, does not mean that a shareholder will necessarily nominate a director at the annual meeting. For any shareholder to be eligible to nominate a director to Penn's board, Penn requires a shareholder to satisfy 4 conditions. First, the shareholder must have owned at least 1% of Penn's common stock for a consecutive 12 months. Second, the shareholder must complete the advance notice paperwork. That's the biographical paperwork package that Jed described earlier. Third, the shareholder must submit this paperwork to Penn by a strict deadline. And for 2025, this deadline is February 4. And this is the prerequisite that we're asking permission to do. Finally, the shareholder must be present at Penn's annual meeting. That's the only forum where a shareholder may formally nominate its recommended director for election by its fellow shareholders. So, as Mandy said, this request by HG Vora is specific and narrow. We are not here before the commission requesting permission for HG Vora to nominate candidates at Penn's annual meeting. We're also not requesting permission to file a proxy statement and other proxy materials with the SEC, which will be necessary if HG Vora does decide to actually nominate director candidates. We understand that both of those actions can only be taken if, in fact, HG Vora decides to take them after the licensure review is completed. So today we're before you only requesting that the commission permit HG Vora to take a limited procedural step. So what does this mean? It means that HG Vora would privately submit the paperwork package to Penn by the February 4 deadline imposed by Penn, and to do so for the sole purpose of preserving HG Vora's eligibility to participate in the nomination process. The submission of this paperwork in and of itself is nothing more than a preservation of rights. It does not mean that HG Vora will in fact do anything more than preserve this right. And this action alone does not impact Penn's affairs or operations. And as Mandy mentioned, unlike a year ago, this request is no longer moot because the IEB thankfully has indicated that it does expect to conclude its review by the first quarter of next year. And to give the commission comfort that this paperwork submission is truly procedural, HG Vora is prepared to agree to certain restrictions. So during the pendency of its licensure application, HG Vora would continue not to take any action to influence or affect the affairs or operations of Penn. And HG Vora is prepared to comply with specific requirements as the IEB may determine are necessary or appropriate to maintain the status quo between HG Vora and Penn. For example, HG Vora is prepared to limit its communications with Penn, refrain from making public statements that similarly situated shareholders could otherwise make, such as press releases, and engage in other advocacy. The one limited exception I'd like to bring to the Commission's attention is that HG Vora would be required to amend a disclosure filing with the SEC to include the mere fact that the firm has taken this procedural step. However, that disclosure would be kept to a minimum, including, and we believe this is significant, treating the names of recommended candidates confidential. So I hope this helps the commission understand the limited nature of HG Voro's request to submit the advance notice paperwork. And I'd now like to turn the floor over to Jed to discuss the statute.
Thanks, Jeff. Chairman, members of the commission, I'm going to take some of the facts that Jeff and Mandy have discussed and talk about them in a little more with a little more particularity in connection with Section 14C. And of course, Todd gave a great explanation of Section 14C, how it governs waivers and the licensing of institutional investors. Obviously, it provides for institutional investors holding up to 15% of a licensee's stock with the ability to have a waiver, as long as it holds that stock for investment purposes only and does not have any intention to influence or affect the affairs or operations of the applicant company. As Mandy outlined in her presentation, HG Voro was issued such a waiver in 2016 that was subsequently deemed forfeited by the IEB in January of 2024. In such cases as this, an institutional investor must apply for licensure, a step that HG Voro promptly took in January of 2024. Section 14C, and Todd covered this, but it's important to what we're discussing today, then governs the conduct of the institutional investor during the licensing process. And again, Todd quoted this and I'll quote it again. The commission shall ensure that the institutional investor meets the qualifications for licensure under said sections 12 and 16 before the institutional investor may take an action that may influence or affect the affairs of the applicant company. The statute, importantly, does not prohibit all shareholder actions. It's conditional. It must be an action that may influence or affect the affairs of the applicant company. As Jeff outlined, our request is limited to the advance notice submission paperwork and not any additional action that may, in fact, influence or affect the affairs of Penn. As the Commission's well aware, it has broad authority to interpret the provisions of the Gaming Act. The Gaming Act also provides significant authority to the Commission regarding licensing of qualifiers, as well as the terms and conditions of those licenses and the process of licensing itself. In exercising this discretion, we're asking the Commission to recognize that the submission of an advance notice at the time and in the form required by Penn is not, in of itself, the same as those actions the statute is designed to address, or said another way, designed to restrict. Rather, we believe it can be more appropriately viewed as a required preparatory or anticipatory step if one wishes to preserve the option of taking a future action that requires licensure. HG Voro's proposed limiting conditions that Jeff outlined also provide appropriate safeguards against actions that may be interpreted as influencing or affecting the operations or affairs of Penn, again, while its license application is pending. By analogy, the submission of advance notice paperwork, as prescribed by Penn and by a deadline imposed by Penn, is akin to registering to vote by a deadline imposed by a state. But whether a person registers to vote, it doesn't mean that person will, in fact, vote on election day. Similarly, the submission of advance notice paperwork and even the submission of licensing applications in any state, including Massachusetts, alone does not mean HG Voro has decided to or will nominate directors at Penn's annual meeting. Any decision to do so would depend on a number of factors in late spring of 2025. But in order to preserve that right and make a decision and exercise that right afforded by Penn to its shareholders, a shareholder, as Jeff outlined, must submit the advance notice paperwork to Penn by February 4th. As described in detail to you today, the submission of advance notice itself isn't an action that may influence or affect the operations of Penn. And we therefore believe it's not prohibited under Section 14C's restrictions. Significantly, if the Commission were to grant HG Voro the limited relief requested, Massachusetts would be aligned with 25 other states in which Penn operates, many of which have substantially similar statutes and, importantly, share the same regulatory objectives. In addition to being permitted under the statute, we believe the proposed path we're putting forward to the Commission today also achieves several important objectives. First, it respects the analysis and position taken by the IEB in January of 2024 as applied to the facts and circumstances at that time. where there was no chance HG Vora would be licensed for the shareholder meeting in June of 2024. In contrast, today, the IEB, it's our understanding the IEB believes that it's likely it will complete its review in Q1 of 2025, which would allow for a licensure determination well before Penn's June 2025 meeting. This means HG Vora could, if it chose to do so, nominate directors at that annual meeting and file proxy materials with the SEC prior to that meeting. Again, only if and when it was licensed. Second, our request doesn't interfere in the license application review and determination in the ordinary course. The IEB continues its investigation. It finishes that investigation on its own terms, and it files a report with the commission. The commission reviews that, holds a hearing, makes a determination on HG Vora's suitability process. Third, our request is specific and narrow. It's limited to these particular facts and circumstances that are before you today. And the risk of a bad precedent coming out of this, I think, is really non-existent because of the uniqueness of this situation, which, as Mandy indicated earlier in the presentation, really has not arisen, certainly in Massachusetts, and our understanding in all the other jurisdictions where Penn is licensed to provide gaming. Fourth, our request complies with Penn's shareholder engagement program described in its annual meeting proxy materials filed with the SEC and published to its shareholders. Fifth, and importantly, it preserves HG Vora's eligibility to exercise at a future time its fundamental shareholder right to nominate director candidates to Penn's board, and HG Vora would only be permitted to take such future action if, and only if, the commission has reached a determination that the firm meets the qualifications for licensure. And sixth, it avoids the inequitable outcome of HG Vora, a long-term Penn shareholder and fully cooperative license applicant, being restricted from preserving its ability to participate in the Penn director nomination process for a second year in a row, where a new shareholder of Penn would not be. What we mean by this is a shareholder and a licensee can show up owning greater than 5% of the licensee and nominate one or more directors, but that shareholder would only be required to submit a license application package within 30 days of acquiring that stock, and would not be subject to any restrictions while ongoing the IEB licensure review and interim and final approval by the commission. We believe it's inequitable for HG Vora, as a long-term shareholder and fully cooperating license applicant, to be restricted from preserving its eligibility to nominate director candidates, while a new investor would not face these same restrictions. And now, to wrap things up, I'm going to turn it back over to Mandy.
Thank you. Thank you. So I'd like to close our presentation by saying that Jed, Jeff, and I recognize that the context of today's issue is new to the commission, meaning the director nomination process for a public company, for a shareholder undergoing licensing that previously held institutional investor status. But I do want to underscore that we believe that the relief that we're seeking is straightforward, it's specific, it's limited, and it's narrow. And that the outcome that we're seeking merely preserves my firm's eligibility to take an action at a future time, an action that may or may not be in fact taken, and in all cases contingent on the successful completion of the licensing process. Our proposal importantly preserves this fundamental shareholder right, while significantly including conditions and limitations on our firm designed to ensure that IEB's processes are respected and not impacted, and that the operations of Penn and its affairs are not actually influenced or affected. And it's for these reasons that we respectfully request that the commission interpret its statute in a way that we believe is fair and equitable. And we believe that our proposal enables the commission to do so without undermining its regulatory objectives or mission. And finally, I'd just again like to thank the commissioners for their time today.
Thank you. We appreciate it. Commissioners, do we have questions at this point, or do we want to hear from everyone first? I see Commissioner O'Brien.
Yeah, I have some questions, but I'd like to hear from everyone first before I ask them.
All right, perfect. All right.
Mr. Chair, Commissioners, thank you, Attorneys Nozzle, Katz, and Lamb. We now, on behalf of Penn, would like to welcome Chris Soriano and Attorney Dan Neff. Chris, good morning to you.
Yes, good morning, Chair Maynard, Commissioners. It's always nice to be with you, and thank you for the opportunity to be here today. I'd like to take this opportunity to thank the Commission, General Counsel Grossman, Deputy General Counsel Stempic, Director Monahan, the entire IEB staff for their diligence and careful review of the matter. And again, thank you for the opportunity to participate today. As a publicly traded company, Penn recognizes the importance of all shareholders having the opportunity to exercise the rights conveyed to them by law and by Penn's articles of incorporation and bylaws, and we view engagement with our shareholders as a matter of great importance. As a publicly traded gaming company, we regard our gaming licenses our company's most important asset and have tremendous respect for the regulatory framework under which we operate across all of our jurisdictions, including here in the Commonwealth. Accordingly, we recognize that in our industry, the exercise of shareholder rights is subject to this regulatory framework, including the rigorous standards imposed on all participants in the industry by statute and regulation, and is particularly relevant here, Section 14 of Title 23K, through which the legislature set out the clear process that governs circumstances similar to the one in which we find ourselves today. I'm happy to answer any questions the Commission may have, and because I am most decidedly not a corporate lawyer, I've asked Dan Neff, one of our outside attorneys from Wachtel Lipton Katz, to join me today. Mr. Neff is a preeminent attorney on corporate governance and securities matters and is thoroughly familiar with the nuances and intricacies of the shareholder nomination and election process. With your permission, Mr. Neff has some comments to make, and both of us are happy to answer any questions that the Commission may then have.
Please proceed.
Okay, thank you. Chair Maynard, members of the Commission, I appreciate the opportunity to address you on the issues that you're considering today. I'm Dan Neff. I'm a senior partner at the Wachtel Lipton Law Firm in New York. I've been a corporate lawyer and securities lawyer for 47 years and have familiarity with the issues that are subject to your consideration. And then, of course, I'm here to answer any questions regarding the implications of a shareholder providing a notice of nomination and filing a 13D amendment to publicize that filing. I think the relevant question here is as both General Counsel Grossman and others have said, it is a narrow issue of statutory interpretation, specifically under Section 14C. Does providing a notice of nomination and publicizing that nomination by means of publicly filing a 13D amendment, does that constitute an action that may influence or affect Penn's affairs? We, of course, defer to the Commission's interpretation of its statute and its licensing requirements, but I'd like to provide our insights as to the consequences of what's being proposed. I will not surprise you to hear that what is being stated to be narrow is not narrow. What is stated to be limited, it's not limited. The request by the applicant is to preserve their eligibility. It will not preserve the status quo for Penn. It will have dramatic impact on the status quo. Now, let me explain. Once the notice of nomination is made, the proxy fight is started. That is how the market interprets these filings. That is how the market will interpret this filing. The SEC filing will generate enormous publicity virtually instantaneously. You will see headlines within an hour or two from the media, which will say, quote, activist commences proxy contest at Penn Entertainment. Market analysts within 4 hours will put out their reviews of what's going on at Penn. The shareholder base at Penn will change considerably, which happens in proxy contests. Longer term holders will sell out to event-driven market professionals. Importantly, existing and new potential investors in Penn will be on the phone constantly. They'll be calling Penn and they'll be calling the applicant, and they will ask things like, who are your nominees? What is their connection to the applicant? What is the campaign platform? And how will you change the company once where your nominee is to be elected? This is not hypothetical. You know, a year ago, we were told by the applicant that they basically demanded the right to have 2 directors, demanded, and they were filing a 13D amendment. I don't know what's changed. What was a demand a year ago has now become a, we haven't made our mind up yet. I guess I'll say no more about it. The communications which will be made by various stockholders and potential stockholders, the calls, they will be impossible to monitor. Who's making the calls, what the responses will be. It's worth noting that the applicant has said that the limitation they're willing to accept is that they will not make public statements. They won't need to. They haven't mentioned private statements. There will be probably hundreds of phone calls, people calling the applicant and saying, what do you have in mind for this company? There's been no mention of that interplay. That is what happens in a proxy contest. That is what would happen here if the extraordinary relief is granted. News of the nomination will significantly alter Penn's dealings with all of its constituencies when it talks to its team members, when it talks to its lenders, business partners, other stakeholders. The first question in everybody's mind is, tell me about the proxy contest. All of these holders and constituencies will want information, which Penn will have. You know, who are the nominees? What's the campaign platform? Penn will probably be forced, either as a matter of securities law disclosure, because they are sitting on material non-public information, or as a matter of their transparency, to speak up, to explain what's coming. They will not. I would be shocked if the information which is privately provided does not see the light of day, and they'll see the light of day very shortly after the filing. When a company is responding to a proxy contest, that activity becomes completely time consuming. It is the primary thing that the most senior executives in the company and the board of directors of a company spend their time on. And it will continue unceasingly from the time of receipt of the notice, which has to happen by February 4th, until the annual meeting, which is typically held in early June. So if the question is, may these actions influence or affect Penn's affairs? Our answer, it will have a tremendous impact on Penn's affairs, and the status quo, that which exists today, will be unalterably changed. I want to comment also on the so-called fairness issue, because that's been raised by a number of the applicants' presenters, that it is inequitable. A year ago, when we were called, we were told in advance of the 13D filing, the applicant switched from a 13G filer, reflecting passive intent, to a 13D filing. We were told that it was going to be done by the end of the calendar year. We counseled them. We said, you know, we would advise you not to do that. You're going to violate state gaming laws, and you're going to poison the relationship between the investor and the company, because there'd been they've been in the stock for a while. There had been a wholesome give and take between the parties. But we said, don't do it. They did it. Now, they did it knowing the consequence would be, and it came out in the IEB's letters in February, in January and February of this year, indicating that the investor exemption had been violated and withdrawn. When an investor decides to go down a path, when they invest in a company, they got 2 choices to make. They could choose the path they chose, or they could choose the investor, passive investor approach. They chose the latter. The statute is quite clear. The statute was prescient in thinking through what happens if you go and then you change. And if you go use that exemption and then you change, it's very clear. And that's why you're being asked to exercise discretion and so forth. And that's why this is, without precedent. It's without precedent in our view because the statute's clear. The licensing has to occur before an action may be taken to affect or influence the affairs of the company. I would point out there are other statutes similar to the Massachusetts statute. The SEC's 13G to 13D, you get an exemption from filing a 13D if you indicate that you're filing for investment purposes only. Hart-Scott-Rodino, the FTC's rules also provide an investor exemption, passive investor exemption. If you violate those privileges, and it is a privilege to be able to proceed that way, if you violate that, there are penalties. Let's not forget, the applicant is in violation of commitments which it made to the commission. So the novel solution is required because the shareholder applicant did not comply with the commitments it made to the Massachusetts Gaming Commission. The proposed solution, were it to be permitted, will trigger the harm sought to be protected against. That is, a shareholder which is not licensed will be permitted to take an action that will definitively and dramatically affect the affairs of a licensed issuer. The action, if permitted, will be very big news in this sector, in the gaming sector. And as you can imagine, this will have significant precedential value for all licensed issuers. With that, I thank you for your time and attention, and I'm available to answer any questions you may have.
Thank you, Mr. Knapp. Attorney Katz, I see your mic's off. I would like to turn to IEB first before I give you an opportunity. I also want to say I want to keep decorum. I don't want to volley back and forth here today. I think the commission has received a lot of materials. We've heard you. So please keep any remarks brief after Director Monahan goes.
Good morning, or actually just good afternoon, everyone. In making a statement today, I want to actually take a step back to start and talk about why the statute exists, why Chapter 23K, Section 14C exists. And in the normal course, as the commission knows, holders of more than 5% stock of one of our operators are deemed qualifiers. And those qualifiers go through an investigation to determine their integrity and ultimately their suitability and whether they should be licensees in the Commonwealth. However, there's an exception, and that's institutional investors. Institutional investors agree that they are not going to influence or affect the operator, and in return, the MGC agrees not to investigate them. So they are able to hold more than 5% of the stock. They would otherwise be deemed a qualifier, but they are not because they make this agreement, this fully knowing agreement. The commission needs to be able to trust that institutional investors are not quietly trying to influence or affect the affairs of operators. And because of this, the IEB believes that the statutory threshold for influencing or affecting the affairs of an operator is both low and clear. It states that the statute states that institutional investors may not take any action that may influence or affect the affairs of the operator. In our opinion, that's very low. And the concern is, of course, that if this line becomes blurry or confusing, other institutional investors will notice that and start to take actions that they should not be taking. And we may never know about those actions. So this is a matter of, if we're going to continue to have an institutional investor status, it needs to be very clear that they are hands off completely from the operator. I'll now turn back to the question at hand, which, as has been mentioned several times, is making advance notice of recommended board members an action that may influence or affect the affairs of the operator. And based on the information that the IEB has learned about the board nomination process, it is our position that making advance notice of recommended board members may influence or affect the affairs of Penn. Therefore, the commission would need to determine that HG Vora is suitable before it makes any advance notice of recommended board members. And our rationale is twofold. First, nominating an individual for the board, which is of course the governing body of Penn, ultimately seeks to influence the composition of the board and the board's decisions. That, in our opinion, is categorically seeking to influence or affect the affairs of Penn. Second, making advance notice typically starts a process of lobbying and negotiating as the entity making the nomination seeks support for its nominees. And this may include, among other things, a settlement with the operator to allow nominees onto the board or a proxy fight. And again, this is an active process as the entity looking for seats on the board seeks to influence or affect Penn. And this all happens ahead of the formal nomination process in June. So we appreciate the commission's time today. We are happy to take any questions. And again, our ultimate ask is that the commission deny HG Vora's request to take this step. Thank you.
Thank you, Director Monahan. I do want to give Mr. Katz just an opportunity, commissioners, to make his point.
Thank you, Chair Maynard. And I will keep it brief. And the decorum part's easy because the truth is we in Penn, we all want the same thing. We want a stable, healthy company, which is a great licensee for the Commonwealth. So a couple things. One, in contrast to Mr. Neff's description, the proxy contest that people read about, hear about, that would begin when we file a proxy statement with the SEC. The names of the nominees, the only way that would be public is if Penn makes it public. We would not disclose that at all. And we would also agree to essentially, until we're licensed, to stand down, to not do anything. Public conversations, private conversations, the things that Mr. Neff described, we would not engage in. So, and it is typical, just to be clear, it is typical for companies and shareholders, once this advance notice is submitted, to enter into a quiet period. It's not an agreed quiet period, but it's a quiet period because they know a proxy contest might come, but they're not going to spend the time, the distraction, the money until they know it's real. And when they know it's real is when an investor files a proxy statement, which in this case, HG Vora would not be able to do until after it's licensed. So I just wanted to clarify, those points, and I appreciate your coming back to me, Chair Maynard.
Thank you. So I'm going to open it up now to the commissioners. I will ask a question, Mr. Katz, based on what you just said, if I may. Did I hear you right when you said including private conversations? And then my other question is there another way that the information could leak out, which is if another investor just happened to leak the information, right? Is that a possibility?
So, no, not in this case, because the submission would only go to Penn. No one else would see it. No one else would have access to it. So there's the only two parties that would have that information. Well, the only parties that would have that information would be Penn and HG Vora. And in terms of the candidates themselves, they would be restricted from saying anything as well. Does that answer your question, Chair Maynard?
It does. I'm just trying to understand how public is public and private is private, and what your proposal actually is. And it sounds like you're saying to keep it completely private. There's going to be no campaign at all.
Correct.
Under your proposal.
Until such a time that we would be licensed. Correct.
Okay. Thank you for that clarification. Commissioners, questions for anyone who's presented? Commissioner O'Brien.
Thank you. So some of that got answered as we went through, the string of everyone speaking. what I am, the two things that I'm struggling with that would tend me to concur with IUB are, despite the representations on the privacy, et cetera, I had that same question too. Is there another mechanism for disclosure, right? And Attorney Katz, you did that. It was like Penn, HG Vora, but also the licensees themselves. Would there be any other legal process or situation where they would be mandated to disclose? Court order, third party, something like that?
None that I could think of, Commissioner O'Brien.
Okay. And I guess the question I would also, I don't know if it's Jed or Attorney Katz or what Attorney Lamb, there does seem to be a distinction in terms of obligations and disclosure for the 13D versus the 13G, licensed, qualified institution and versus institutional investor. And I think, as Attorney Monahan said, May is a very low bar. The mere fact of indicating you may do something in the future, I'm struggling with not seeing that, just that sheer fact influencing in contravention to sort of the institutional investor status until you're licensed. So if somebody could speak to me more on that, because that to me is really what has me concurring with Attorney Monahan and Penn at this point.
So thank you, Commissioner O'Brien. That's a great question. And before I ask Jeff Katz to weigh in on this, I would say it's a question that we have been discussing extensively with gaming regulators in up to 26 states. As Jed mentioned, many of you have substantially similar, if not the same statute, and have taken widely varying interpretations of what rises to the level of actual influence. And we do believe that this step, this action, is limited and procedural in nature to preserve eligibility to be able to do something at a future date. There are a number of states that have viewed it similarly. There are some states that do believe that in order to, in April or May, submit proxy materials and in June stand up to formally nominate directors, that one does need to be fully licensed at that point in time. I'm pleased to say we've been able to get through that process relatively smoothly in terms of based on bandwidth within every state. And I'd say that the one, putting aside the loaded term proxy contest, which again wouldn't start until, if it does start, until say April, this fits within what I would describe as Penn's shareholder engagement program. And, we thought it was helpful to attach as an appendix the way in which Penn frames its nominating and governance committee processes, whereby it actually says that it wants to consider board nominees from its shareholders. And it goes through a process by which it, clearly states in its materials that if a shareholder is interested in basically throwing hats into a name, it'll consider them, whether they think they're qualified candidates, and potentially even put them on their own slate for election. And if for any reasons they don't find those candidates interesting enough or qualified enough, the shareholder nonetheless has the ability to stand up and nominate them themselves in June. And so this nomination or the paperwork process is what sets that in motion. And, that's again, a preservation of eligibility, but also responsive to putting names into a hat, which Penn has also publicized, which don't necessarily lead to a proxy contest. Jeff, is there something that you maybe might want to add at this time?
Yeah, I would just, Commissioner O'Brien, thank you for the question. I just want to add, look, we recognize that this is a bit of a pickle because we don't know what we're going to do come spring, things could change. Things at Penn could change. Their performance could change. Things could change. There could be discussions with Penn that make things change. Anything could happen. But the problem is we have this deadline, this February 4th deadline. And so in terms of just putting in the paperwork, it truly is a preservation of a right. And as we described in response to Chair Maynard's questions, we would just stand down until we're licensed and not take any activity that we would be restricted from taking until we're licensed. And if Penn wanted to, waive the deadline and move it further in the year, we're happy to discuss that as well. But, for now, as we discussed in our presentation, this is a prerequisite, but at the same time, it does not mean that we are actually going to do anything, at a later time. Similarly, Commissioner O'Brien, we're going through this licensing process in all these states, and it's analogous to submitting this advance notice paperwork.
Thank you, both of you. The thing that I still struggle with, I think about when I had cases, right, and someone would file a notice of appeal. In theory, you're just preserving your right, but it does influence the posture of the matter. And this is a May. Something else that you said did strike me as well in terms of asking us to exercise discretion to create an exemption that's not necessarily clear, is whether there is a solution amongst yourselves that doesn't involve our process in making exemptions, right? In terms of an extension. And to the extent, and I'm not asking for any discussions on that, but to the extent that it is either not happened or has happened and been unsuccessful in your view, to me, that's also a May influence factor for me. So it is a bit of a catch-22. I know that IB is working diligently to go through the requirements. But for me, I think that May language and where we are factually, I'm still coming down the line with IB's recommendation.
Thank you, Commissioner O'Brien. Commissioner Broder, I see your mic's off.
Yeah, thank you, Mr. Chair. I think might be a little bit redundant to what Commissioner O'Brien said. There's the theoretical versus the practical, and I think that's what we're wrestling with here. Not to be flip, but the game is clearly afoot, or the effort over 2 years to maybe theoretically exercise a right seems to me to be a lot more than, from a practical point of view, just preserving rights. And I'd love a commentary from any of the parties on this. It seems pretty clear to me that the end game here is to exercise some influence over Penn and to move the process along creates leverage for HG4 that otherwise wouldn't exist. There clearly can be private discussions among the parties, but what is the posture of those discussions if we take this action versus if we don't take this action? We don't create the exceptions. So I feel like even our decision is going to have an effect on how the various influences parties bring to the table to exercise even in a private conversation really matter. And honestly, I'm also concerned about, as maybe too new to have a lot of wisdom here, but the idea that this is a very limited situation concerns me. I'm not sure. It's easy for me to imagine, I guess I would say, that institutional investors would always be interested in changing their status if they have concern about the direction of the company in which they own shares. So this maybe seems like a moment in time or a unique situation. It strikes me as something that could very easily come up in the future with a so-called passive investor. So if I'm missing something, I guess, please enlighten me.
I think that is a very important issue that you're identifying, which I'd like Jed to speak about, because the amount of time that has lapsed from the institutional investor waiver that we had in 2016 and the licensing process that effectively takes upwards of a year, I think is particularly meaningful in that this setting a precedent. We just have a very difficult time imagining how many other situations can arise that could undermine the processes that the IEB has in place, as well as the commissioner's goals about ensuring that applicants or shareholders are appropriately licensed where the statute requires. Jed?
Thanks, Mandy. Thanks, Commissioner Brodeur. I think I'd start with the uniqueness of the status of HG Vora. And again, it's my understanding, and staff can correct me, this has not occurred in the almost sort of 12 years that the Gaming Act has been here in Massachusetts. And again, we haven't seen this in the other jurisdictions as well. And if you look at 14C, and Todd alluded to this in the beginning in his presentation, it doesn't apply to all institutional investors, right? This restriction. It only applies to an institutional investor who's then required to be licensed. And that's a very limiting group of entities. And then I would suggest that what we're seeing here is the uniqueness of the timeline and the necessity of what we need as a preparatory or anticipatory step in order to keep within a timeline and preserve a right. I think these are very unique circumstances that don't lend themselves to likely repeating themselves. And again, the statute is very limited, not to all institutional investors, but an institutional investor that then is subsequently required to be licensed. And that's I can say, a rare occurrence to begin with. The other piece that I want to just comment on as well regarding sort of the safeguards that the company has represented. These have meaning. They have teeth. We are an applicant for licensure, and we are telling you that we are going to meet certain conditions around our conduct in connection with this process in exchange for being able to preserve our rights here. And to me, those things have an incredibly important meaning and are fully enforceable by the commission in essentially having to still go through and approve the company's licensure. The company is not going to propose conditions and then not meet them. So I think these safeguards that have been proposed will be met, and they can be documented and continue to be part of the IEB's review of the company's conduct.
Council, I'm not concerned that this is some kind of a bait and switch, or is HG Vora trying to create some operating room where they can do an end run around what the IEB is trying to do in terms of upholding its responsibilities. I have no question about that. And I am sympathetic to kind of the nature of the marketplace here, where investment markets tend to move very quickly, and regulators, for good reason and by mandate of the legislature, have a responsibility to be very deliberate and methodical in a way that doesn't always bluntly suit the needs of the investment market. So I am sympathetic in that respect.
If I could also just add, we find ourselves in a difficult situation with Massachusetts merely because of timing, with the February 4th deadline that's imposed by Penn for us to be able to preserve our rights here. alongside the licensure review process within the IEB. We understand that's expected to be completed in Q1 of next year. How close to the February 4th date, we don't at HG Bora have insight into that, but we do know that our interview is a week from today. And so we don't know to what extent that approval could be processed before the 4th. And it would be, but we do understand the expectation is it'll be well before the end of Q1.
If I may briefly also just add a couple things. One is, it is not theoretical that there are investors who have filed these the advance notice paperwork who did nothing more, never engaged in a proxy contest, never had anything done. They just sat on the sidelines and kind of watched what happened. And I presume that that's because things happened that they, eventually didn't disagree with. And then the other piece I just want to underscore, this would not be business as usual, that as we've said, we would agree to guardrails that the IEB determined were necessary, appropriate, and that we wouldn't behave the way that any other similarly situated shareholder would behave. It would be, we would just agree to that quiet period we discussed until we were licensed. So I just want to, just underscore those two things. Thank you.
I appreciate that, Council. Mr. Chairman, I'm all set.
Thank you, Commissioner Broder. Commissioner Skinner, I see your mic off.
Yes, thank you, Mr. Chairman. Could someone clarify for me the two different, I think I heard that there were two different SEC filings that were required in this process, the proxy statement, and there's one that gets filed almost immediately after approval is given if the commission decides to do that.
So I can take that. The proxy statement, these are public filings that happen. In this case, if there was a June meeting, they wouldn't happen until early April at the earliest. And those, the company would file its proxy statement, and that would include its recommended nominees for directors. It would provide information to shareholders about all sorts of information about the company. And these are, has a lot of annual report information. That's and the company would file that. If when an investor does engage in a proxy contest, it files its own proxy statement at the same time. Again, this would be early April. So after, hopefully, and it wouldn't be filed until HG Bora is licensed. And that would include, it would make public the information that otherwise would be private. In other words, the biographical information of the nominees. But that wouldn't happen until early April.
And that's presumably after licensure has been granted.
Correct, Commissioner Skinner. The other filing refers to a filing that exists. It is a filing that has already been made with the SEC. And with those filings, there's an amendment regime, and HG Bora would need to, and we're talking about the amendment would be 2 sentences. It would state, on such and such a date, HG Bora submitted an advance notice. With 2 or 3, up to 3 recommended candidates for the board. It would not include the biographical information or the names. It would be a factual statement, and that would be required if again, HG Bora is permitted to take that step and file that paperwork.
And what kind of response do you expect from shareholders upon that filing?
So after that gets filed, it is typical that there is some market attention. Just like any news cycle, it depends on whether the flames are fanned or whether there's no response. And so it varies from company to company. Unfortunately, there is, like, you do have people that look for things, they look for content. So I imagine it would get picked up, but in typically an investor would then ride that and try and create more and more news, more media. And what we are saying, we will not do that. We will not say a word. And so if we don't say a word, then it's up to the company what kind of media there is or isn't. But in many, many cases, what happens is there's a filing, there's a mention, and then it goes quiet until that early April time where the proxy contest starts. And then, yes, you have a lot of attention and a lot of media.
But whether you withhold the names of any individuals you intend to nominate, just the mere filing of that amendment would generate some buzz. Is that...
Yes, that's accurate.
Okay. And then my next question is for the IEB, Director Monahan, and perhaps our legal counsel. How should we be looking at, because I'm focused on, for the moment, this perceived equity issue. How does the forfeiture of the institutional investor waiver, how does that, what in that process triggers a more scrutinized, if you will, requirement of not acting to influence or control the affairs, right? That's different from a brand new investor who comes in and is seeking to influence or control the affairs of the licensee, but is only required to submit the paperwork once the application is deemed complete. They are then free to actually influence or control the affairs of the licensee. So what am I missing there? What triggers in this institutional investor process whereby the waiver is forfeited? What triggers the additional restriction?
So the difference here is between the statute for institutional investors and the regulations for qualifiers. So it's the statute, chapter 23K, section 14C, that sets out that the commission has to approve the suitability of the former institutional investor or the entity that had sought institutional investor status prior to being able to seek to influence or affect the affairs of the operator. Qualifiers are in different situations. So a new qualifier that buys, the new entity comes in and buys 6% of an operator, and it files its paperwork, and as soon as its application is in and deemed complete, it can continue on, and that's regulatory. So I think we absolutely recognize that there's a distinction here, right, between these two different actors. I think the reason for this, the way the statute is set out the way it is because becoming an institutional investor is an incredibly serious decision. Again, because you own more than 5% of the company, so you have a significant amount of stock in the company and potential influence in the company, but you make a decision that I am not going to impact the influence or affect the affairs. My hands are going to be off from the company, totally. And because of that, we don't investigate the institutional investor. There's no investigation. The institutional investor needs to know how serious that is, and I think the statute makes that clear because they can't just change their mind. They can't just decide, ooh, I was an institutional investor, I don't like how it's going, now I can flip the switch and very quickly just become a regular investor. Everyone would want to be an institutional investor if that was the case. Everyone would come in and say, oh, I'm not going to influence or affect until I want to. So there's a period. There's basically a cooling off period almost that, that the institutional investor has to go through this background qualifier check before it can take action. So that's why, when I read the statute, that's how the statute makes sense to me, and that distinction between institutional investors and or a new qualifier.
Commissioner Skinner, or Chair, if I may respond briefly. I agree with Director Monahan to the extent, and I want to be clear about sort of what we're asking for and what we're not asking for here. We're not asking to take actions we feel that could influence or affect that, again, any other shareholder would be able to do if they were a new shareholder coming in, as long as they never held that institutional investor status. We've gone through the process, and we're only asking, again, for this preparatory and anticipatory step to be made. And I would suggest, Commissioner Skinner, that that is just a small step towards fixing what I think is an inequity in Chapter 23K in the way that it treats these applicants. It makes no sense that a new owner of the same amount of stock could come in and do exactly what they wanted to do, engage in this process, and merely have to provide essentially an application and go through an approval process, but have all the rights that attach to that shareholder's stock while they go through that process, versus an institutional investor who either made a decision, or in this case, the IEB found that it had forfeited its case, is going through that exact same process for licensure, yet has this set of restrictions. And again, we're not asking you to fix that, because you can't. That's the way 23K appears to operate. But we're saying you can take this very small step to address some of this inequity. And I think for an important constituency in Massachusetts for the industry, which are investors, and allow the company essentially to preserve the right to ultimately engage in the same exact activity that new shareholder would be able to engage in. So it's again, we're not asking you to, and I don't think we're asking to take steps again that influence or affect the company, but rather just preserve the right to the extent we get through the licensing process in order to get there someday. And then all the parties essentially would be equal.
Mm-hmm. Question to Attorney Katz, I think. In that initial filing where I think you talked about 2 sentences, you're communicating your intent to engage, or you're preserving your rights by disclosing your intent, if you choose to exercise it, to nominate directors during this process. Is there a limitation to what kinds of information that could be included in such a disclosure? For instance, is there, if this commission were to include a condition that some additional language be included in that disclosure, is that something that could be accommodated? And a language that sets forth the restrictions that, or additional conditions that you're proposing here today, should the commission decide in your favor. Would you have the opportunity, or would HG Vora have the opportunity to include those conditions in this filing?
We could, Commissioner Skinner. And we'd be happy to do that. And just to be clear in this filing, it is a factual filing. You know, for instance, an investor that changed its holdings by 1%, so bought and sold, so it changed, that investor would have to also amend its filing. The idea is any material change, you have to just provide a factual filing. But we could include, as you suggest, the type of language you suggest.
All right, thank you. That's all I have for now, Chair.
Thank you, Commissioner Skinner. Commissioner Hill, anything to add?
All my questions have been answered by my fellow commissioners.
All right, I guess I'll go ahead and kind of tell where I'm thinking here. And I jotted down a few of my notes as we were talking. I don't like the commission being used as an instrument by Penn National or HG Vora. And what I hear today is a shareholder in a company who are not agreeing to a whole host of matters and trying to use this one point of law in this one jurisdiction, really score a point or a win here. It's not really fair to the commission to have to think about these broader concepts. And so I feel like I have to drill down and think about what's really before us here today. What I hear is that an institutional investor decided to change its status. It's now mid-licensure. The licensure is not complete. Whether or not it's done by February 4th is really no consequence to me when interpreting the statute. What is of consequence to me is that I think even under HG's proposal, it's an attempt to influence the affairs of them. I'm not sure how we would police whether or not the nominees or parties would leak nominees. I'm not sure how we would, what we would do if it was violated. I imagine we'd be sitting right back here and people would be pointing at the fingers at each other on who leaked what name, when, where, and how we're supposed to undo all that and figure out what we do with it once that happens. So I just really have to look at the law, right? And I understand the inequity here, Attorney Nozel, Attorney Katz, I hear you as to the statute. With that said, my interpretation here is that HG Bora needs to be fully licensed. And, you know, I would like to think that it could be done at some point relatively quickly. But that's where I am right now. That's where I'm standing as one commissioner. I don't want to be used as a volley in this. I want to just, that's where I am. Commissioner Skinner, I see your mic's off.
Yeah, I'll just share more about where I'm coming from. I appreciate the parties raising this question with the commission. I think it is an important one, and I think it's a legitimate one, whereby we are being asked to, I don't see this as a request to interpret the statute. I think that statute is clear, and I think we all agree that the statute is clear. I'm not willing to go against IEB's determination that making public HG Bora's intent is not a, or excuse me, I'm not willing to go against the IEB's determination that making that disclosure public, making that intent known is an act that is furthering in furtherance of controlling or influencing the affairs of the licensee. I, however, am really struck by the equity issue that has been raised. I understand that we're dealing with the statute versus the regulation that the commission has promulgated. I don't see the wisdom of treating the two categories of investors, qualifiers, differently in this particular scenario, because again, a qualifier is able to walk right in and sit at the table and pull the trigger on pretty much anything involving the company. Yet in this situation, due to the statute, there's a limitation on institutional investors who decide that they want to broaden their interests. I would be interested in issuing some kind of waiver if that is at the commission's disposal. I'd like to get to a point where the commission is not, and I don't want to put it this way because it's not that we are standing in the way of HG Vora exercising their right as a shareholder. I want to get to yes here. I think that we have the tools to be able to do that, and I'd like to see that happen. The other thing too is I'm also satisfied that the IEB will complete their investigation in the earlier piece of Q1. I've had conversations with the IEB Director Monahan, and there's no timeline for sure, but I have been assured that the investigation will be complete Q1 of 2025. And so that's where I stand right now. Thank you.
Commissioner Broder.
Mr. Chairman, thank you. One further thought, and I'll be brief. There seems to be consensus about, what is allowed under the statute, and I have heard quite a bit about the commission has great discretion, and in some cases that's true, and no regulator ever certainly speaks up for limiting their own authority. But given that the statute is fairly clear, the idea that we could carve out an exception, I'm not sure where that authority lies, given what seems to be the clarity of the legislative intent. Even if it leads to an outcome we might not like, we are, circumscribed by the statutes and have to live within them.
Thank you, Commissioner Broder. To that, I would like to hear from General Counsel Grossman.
I don't think you can carve out an exception or grant a waiver from this requirement. If you are to conclude that the act of submitting this notification may influence or affect the affairs of Penn, then the answer under the statute, as you've been discussing, is that HG Vora is not allowed to do that. The avenue you could pursue, if you were so inclined, would be to find that the act of submitting the advance notice, as has been described, would not be designed to influence or affect the affairs of the company. So that's really the only course of action that I see here. Because this is in the statute and not a regulation, the commission does not possess the ability to grant a waiver or a variance of any kind.
Commissioners. We've all heard Councilor Grossman. We've heard everyone. Commissioner O'Brien.
Yeah, I mean, I am in the same spot that I was, after I listened to everyone, which is the statute is what the statute is. I think IEB's assessment that it may influence is substantially supported by what we've heard. I don't enjoy being in this position either. This happens to us periodically where we have to weigh in a process and we feel like we're unduly influencing someone else's process. I'm not fond of it. It may be at the end of the day, if it happens to finish, the investigation before that, we're not in the way of anything. But I think given the statute, the reg and the facts in front of us, the request by HG Vora to do what it's doing without triggering anything, I do not support that. And I would be in opposition to that, consistent with IB's recommendation.
Mr. Chairman, that's exactly where I'm at.
Well,
Mr. Chair, I don't mean to interrupt your deliberations, but I am. So I apologize. I did want to point out, and it may be at least worth exploring. It's something that Commissioner O'Brien mentioned. I think Commissioner Skinner alluded to it as well. Is the completion of the licensing process solves this problem? I'll be frank. I think we were reluctant to want to lead with that, and I think suggest that we put a particular timeline around completing this. And I can see Commissioner O'Brien not in favor of that. I'm not suggesting rushing it in any way, and I understand sort of the concerns with that. But if there is anything, and I'll couch it this way, that HG Vora can do in order to facilitate the completion of that process, we are, of course, 100% behind doing that, whatever resources are necessary for that to happen. We understand that impacts staff, and we certainly understand. And Mandy was complimentary of the IEB's work. We have the interview scheduled in a week. It would be tight, admittedly, but I would be remiss if I didn't say, is there a pathway forward that essentially would moot this issue?
Director Nozel, that's a perfectly reasonable interruption of our deliberation and request. I agree with Commissioner O'Brien as the statutory head of the IEB. I will tell you, I would never force an investigation to go quickly, just to go quickly. It's got to be thorough. That said, I'm also offering up at least my calendar, and I imagine my fellow commissioners would agree that if the calendars happen to line up and everything lined up, we would do what we could to accommodate you. We've been very nimble and flexible as a commission. And really, my commentary on where I feel like we are in this process is I would also like to see you guys get together and come up with something. Commissioner O'Brien alluded to it right out of the gate. There are many ways out of this, right? And I just have to interpret this statute. It's not personal. I have to interpret the statute as I see it and what I'm hearing from our director of the IEP. So that's where I fall. But your point's well taken, Jim.
Mr. Chairman, I guess at this point, I would move that the commission deny HG Vora's request for the relief requested.
Do we have a second?
Yeah, I was just looking for the language. Second.
All right, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Broder.
Aye.
And I vote yes, 5-0. All right, I need a 5-minute break. So let's, I see Dr. Lightbound just came on, but let's meet right after 1 o'clock, please. Does that work for everyone, 5 minutes? All right. All right, Connor. Give everyone a second to get back on. Commissioner O'Brien, just a second. All right, this is reconvening of the Massachusetts Gaming Commission. It's approximately 1:05. We're holding this meeting virtually, so we will do a roll call. Good afternoon, Commissioner O'Brien.
Good afternoon, I'm here.
Good afternoon, Commissioner Hill.
Good afternoon.
Good afternoon, Commissioner Skidder. And good afternoon, Commissioner Broder.
Good afternoon.
All right. With that, we are going to turn to item number 6 on our agenda. And commissioners, get ready. We have a lot of votes scheduled here and a lot of conversations. We're going to start with Dr. Lightbound, the Director of Racing. Good afternoon, Dr. Lightbound.
Good afternoon. So before we start on the items, I just wanted to mention and acknowledge that we did, the commissioners and the legal team and I did receive an email from Paul Umbrello, Executive Director of the New England HBPA over the weekend, just stating that they do not have a purse agreement with Suffolk Downs yet. Bruce Barnett for Suffolk Downs sent out a memo discussing the issue afterwards, and Executive Director Dean Serpa was also included on that. These are two separate items. We don't need to take this item off the agenda for today. As a matter of fact, when I talked to Paul Umbrello about it, he said it was for FYI purposes. He was not trying to get it taken off the agenda for today. They're meeting later this week, and hopefully we'll come to some sort of an agreement, and we'll, stay tuned on that end of it. The legal team, Todd and Justin, are well versed on this. If anybody has questions for them, and Bruce Barnett is on the call as well.
Commissioners, I'm good with that explanation from Dr. Lightbound. I appreciate, Dr. Lightbound, you thinking about keeping us updated on that, as I know we did all get that email in response. So anything, commissioners, for Dr. Lightbound on that? All right.
Okay, thank you. So we'll start with the Plain Ridge requests. As you know, these requests were all included in their application for racing. And so it starts on the packet, page 49. And it's their request for the simulcast export. And that was presented to the commission as part of Exhibit 28. Steve O'Toole is on the call today if anybody has any questions for him. And otherwise, my recommendation is that the commission approve the request for the simulcast exports listed in Exhibit 28 of their application.
Mr. Chairman,
Commissioner Hill.
after sitting down with Dr. Lightbaum, I feel very comfortable moving forward with the proposal.
And commissioners, we know that Commissioner Hill takes the lead on a lot of our horse racing materials. Any questions, comments?
Mr. Chairman,
Commissioner Hill.
I move that the commission approve Plain Ridge Park's request for approval of the simulcast export signals for 2025 as included in the commissioner's packet and discussed here today.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner. That was an aye, and Commissioner Broder.
Yes.
And I vote yes, 5-0.
Okay, thank you. Our next item begins on page 67 of the packet. It's the Plain Ridge request for simulcast imports, and that was part of their Exhibit 27 of their racing application. And again, my recommendation is that the commission approve this item.
Mr. Chairman,
Commissioner Hill.
after discussions with Dr. Lightbaum, I'm very comfortable moving forward with this request.
Commissioners? Commissioner Hill.
Mr. Chairman, I move that the commission approve Plain Ridge Park's request for approval of the simulcast import signals for 2025 as included in the commissioner's packet and discussed here today.
Second.
Thank you, Commissioner Skinner. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes, 5-0.
Thank you. Our next item is found on page 72 of the packet, and it's the Plain Ridge request for a premium free period. They've asked for Sunday, June 15th of 2025 through Saturday, September 6th of 2025. And again, this is part of Chapter 128C. And my recommendation is that the commission approve this.
Commissioners?
Mr. Chairman,
We're making you earn your keep today, Commissioner Hill.
we've had a lot of discussions and, things have moved very well in the past. And after discussion with Dr. Lightbaum, I feel comfortable moving this forward as well. So with that said, I move that the commission approve Plain Ridge Park's request for approval of their premium free period for 2025 as included in the commissioner's packet and discussed here today.
Second.
Did we name the 2025 account wagering? Is that where we were? Or
The
was it-
premium free period is where we were.
All right, I missed my spot on there. All right, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0.
Well, thank you. Our next item is found on page 74 of the packet, and that's Plain Ridge's request for account wagering company. They use the Hollywood races. Back in October of 2016 was the first time this was brought forward to the commission, and IAB and all did some, was involved in this at the time as well. So my recommendation on this one is to approve Hollywood races as the ADW provider for Plain Ridge for 2025. Any questions?
Just to say I moved forward on the packet, so I'm sorry about that, Commissioner Hill.
I actually saw that Commissioner Skinner's mic was off, so I will defer.
Happy to give you a rest, Commissioner Hill. I move that the commission approve Plain Ridge Park's request for approval of the account wagering provider for 2025 as included in the commissioner's packet and discussed here today.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0.
Thank you. Our next item is a request for reimbursement from Plain Ridge, and it's found on page 76 of your packet, and I'll turn it over to Chad Borick to discuss this item.
Thanks, Alex. Good afternoon, Chair and Commissioners. Each month, funds are deposited into the Harness Horse Promotional Trust Fund that our licensees can use to engage customers to increase attendance and handle. Distributions are made upon the Commission's approval of the licensee's request for consideration, followed by a request for reimbursement. Today, Plain Ridge is requesting reimbursement in the amount of $46,500 for handicapping, contests, and advertising. The funds will be used to reimburse Plain Ridge for payouts made to all winners of the contests, along with payments for the billboard advertising. I did review the requests and supporting documents, which are included in the packet. These include winner acknowledgement forms and an invoice from the advertising company. Each prize amount was paid out in the manner that was stated in the consideration, and monies were paid to the advertising company. The preceding request for consideration was approved by the Commission on February 29th, and the fund currently has a balance of over $300,000, which does include approval should this request go through. And with that, I do consider the request to be in good order and recommend approval.
Commissioners, questions for Chad?
Good job.
Do we have a motion?
I move that the Commission approve the expenditure of $46,500 from the Harness Horse Promotional Trust Fund to Plain Ridge Park Casino in accordance with General Law, Chapter 128A, Section 5G, as included in the Commissioner's packet and discussed here today.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0. All right. I think that concludes PPC's requests. Is that correct, Dr. Linepound?
Yes, that is correct. We can move on to Suffolk's requests now. Their requests start on page 87 of the packet, and that is their request for simulcast import locations for 2025. Michael Buckley, COO, is on the meeting today, as well as Bruce Barnett for Suffolk Downs. As you know, these locations are usually approved as part of the racing license application for live racing, but Suffolk is not racing live, so they've submitted the letter dated December 6th with the locations. And my recommendation is that the Commission approve this request for the simulcast locations listed in the December 6th, 2024 letter. Any questions?
Hello, Mr. Buckley. Glad to have you. And Steve jumped off before we could say thank you to Steve, but Commissioners?
Mr. Chairman, I sat down with Dr. Lightbaum and very comfortable moving forward with this request.
So I just have one question for clarification purposes, which is when you're talking about location, it's location of signals being imported, right? Not that they're fixing this physical location for 2025 in its entirety? In terms
Right,
of
they're
the
bringing
Massachusetts
signals
location?
into Tibet, yes.
Right, okay, thanks. Brad's looking at me like it's my turn.
I don't want to hog them all.
You do such a good job.
Thank you.
I move that the Commission approve Suffolk Downs' request for approval of the simulcast import signals for 2025 as included in the Commissioner's packet and discussed here today.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
and Commissioner Broder,
Yes.
and I vote yes.
Thank you, Commissioners. The next item starts on page 91 of the packet, and it's the Suffolk Downs request for their premium free period for 2025. They've asked for October 9th through December 31st. And Again, that's part of 128C. And I do recommend that it be approved. Any questions?
Mr. Chairman,
Hey, Commissioner Hill.
I move that the commission approve Suffolk Downs' request for approval of the premium-free period for 2025 as included in the commissioner's packet and discussed here today.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes 5-0.
Thank you, commissioners. The next request for Suffolk Downs can be found on page 93 of the packet, and it's their request for approval of their advanced deposit wagering companies, vendors for 2025. It's all of these have been previously approved by the commission. There are no new ones this year. Express Bet and its affiliate First Bet, TVG, Twin Spires, FanDuel Racing, Naira Bets, Bet MGM, Caesars Racebook, GK Horse, and AmWest Entertainment. Its platform known as AmWager. My recommendation is that the commission approve these. And are there any questions?
Questions, Commissioner? Commissioner O'Brien?
So Alex, none of these are new, right?
Correct. None of them are new. They've all been approved previously.
Right. We all set? I move that the commission approve Suffolk Downs' request for approval of the account wagering providers for 2025 as included in the commissioner's packet and discussed here today.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes 5-0. All right, Dr. Lightbound, does that conclude Suffolk's matters?
Yes, it does. Yes, it does conclude it.
All right, well, thank you, Mr. Barnett and Mr. Buckley.
Thank you very much. Appreciate the time today.
Thank you. I see Sue has joined us from Raynham. Hi, Sue.
Good afternoon, everyone.
How are you?
So our next items are the Raynham items. And as you see, we have Sue Rodriguez with us today for those. The first item starts on page 95 of your packet. And if just a refresher, they do business as Massasoit Greyhound Association for part of the year and as Taunton Dog Track for the other part of the year. So on the request, you'll see request for each of those, but it's basically Raynham Park. So they submitted a request dated December 2nd, 2024 with their simulcast request sites for 2025. And I recommend that the commission approve those. Any questions?
Commissioners? No questions for me, Dr. Lightbound.
Okay.
Mr. Chairman.
Commissioner Hill.
And Dr. Lightbound, this is for the input signals, correct?
Right, they're bringing signals in from outside to bet on. Yeah.
Yep. So with that said, Mr. Chairman, I move that the commission approve Raynham Park's request for approval of the simulcast input signals for 2025 as included in the commissioner's packet and discussed here today.
Second.
Thank you, Commissioner Skinner. Commissioner Hill.
Aye.
Commissioner O'Brien. All right.
Aye.
Order. Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Broder.
Aye.
I vote yes, and I'm going to do right now Commissioner Hill's trick of pinning everyone to the top, so I don't do that again.
Because that one was 7-0, Mr. Chairman.
Okay.
Okay. So our next item for Raynham is their request for approval of their account wagering system. Their system is Dial to Bet, which has been used for over 20 years. And my recommendation is that the gaming commission, that the commissioners approve this request. Any questions?
None for me.
I move that the commission approve Rain Park's request for approval of the account wagering provider for 2025 as included in the commissioner's packet and discussed here today.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0. All right. Does that conclude our matters, Dr.
Yes,
Hadd?
that does conclude the racing matters. Thank you very much.
Thank you, Sue, for being here, and hopefully that took care of everything you needed.
Thank you. Appreciate it very much.
All right. We are now going to turn it over to the Chief of Sports Wagering, Carrie Teresi, who has a couple of matters for us. Good afternoon.
Thank you. Good afternoon, Chair and Commissioner. So the first item that we have for you today is a request from the Sports Wagering Division to issue a temporary waiver to FanDuel from the requirement in 205 CMR 248.044 that requires the use of identity authentication questions as part of the operator's KYC process. As you know, that regulation requires that operators use these identity authentication questions as part of their KYC, or in the alternative, they can use other methods, but then those methods need to be approved by the commission. FanDuel does use identity authentication questions, but they use them as part of a tiered approach, meaning that the questions are a second step that might be reached by patrons, but wouldn't always be reached. So because the required questions wouldn't be used in every instance, their current approach doesn't technically meet the regulatory requirement. FanDuel did seek approval of their alternate methods several months ago, but was told by the Sports Wagering Division that approval wasn't required because they were using these identity authentication questions. Upon review now, we see that was done in error and that approval is required by the commission. So we are now requesting that the commission issue a temporary waiver to FanDuel to bring them into compliance with the regulation, and we will bring FanDuel to the commission in January to present those excuse me, alternate methods for approval.
Thank you, Chief Teresi. I'll take this moment to say that I appreciate the willingness of sports wagering to acknowledge the fact that what happened here and the posture of where we are today, and just to say that, you know, within any organization, things happen, right? And that's okay. What's important is to make sure that they're corrected and to make sure that everyone's honest about what happened. So we appreciate that, or I do. And I think I speak for us all. Commissioners.
Mr. Chairman, I just want to say to our Director Teresi, thank you for the meeting that we had, our 2x2, to understand this. And I too appreciate all the work that's gone into this, and I'm okay moving forward with the request.
All right, commissioners, anything to add, or do we have a motion?
Mr. Chairman, I move that pursuant to 205 CMR 202.032, the commission issue a temporary waiver to FanDuel through February 6, 2025 from the requirement in 205 CMR 248.044 to use identity authentication questions as included in the commissioner's packet and discussed here today, as granting the waiver meets the requirements specified in 205 CMR 102.034 and is consistent with the purposes of General Law Chapter 23N.
Second.
Thank you. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes, 5-0.
Great,
All right.
thank you very much. And for our second item, I will turn it over to Compliance and Operations Manager, Stefan.
Thanks, Carrie. Good afternoon, commissioners. Only item for me today, because on page 106 of your packet, with a House Rules revision from DraftKings. As you may remember, this was first presented during our December 5th public meeting. Nothing has changed with regards to DraftKings revision, but for your convenience, I'll run through it again. This revision comes as a single change to DraftKings House Rules for soccer, specifically for pre-live same-game parlays. Due to DraftKings taking the same-game parlay technology in-house, this change, if approved, would align more with the rest of their sports-specific sections for those pre-live same-game parlays. The change itself is within the preceding red line documentation with the new proposed language at the top of page 108. And it states that in the event a pre-live same-game parlay contains a selection which is settled as void or push, the parlay will be repriced based on the odds available at the time of bet placement. And if all selections are settled as void or push, then the whole bet will be settled as void and the initial stake returned to the customer. And what's meant by based on the odds available at bet placement is the customer would not receive any better or worse odds, but rather the same odds for their parlay as they did when they placed their initial wager. The parlay would not be repriced on any newer or updated odds for their selections. Excuse me. The changes to the settlement rule more closely align with the customer expectations of how bets are settled and how DraftKings settles similar bets on the other markets and sports within their house rules. For example, if you wager for soccer on a game winner as a selection in your same game parlay and the game finishes in a draw, the same game parlay will be repriced based on the remaining legs, similar to a regular parlay. But instead the entire same game parlay being settled as a void. This change would provide for a better customer experience. And that's it for our review for this revision. Our team would recommend this change for their soccer section to align with the other sports, as well as help clarify settlement for these wagers for the patrons. Chair.
Thank you, Andrew. Commissioners, questions for Andrew? Commissioner Skinner.
I don't have a question, just a thank you for sending along those soccer specific rules. I'm satisfied with what I've reviewed, and so thanks for the additional time, my fellow commissioners, to review those. And with that, there are no other questions.
I have none.
I move that the commission approve the updates to DraftKings House Rules as included in the commissioner's packet and discussed here today.
Second.
Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes, 5-0. Thank you, Andrew.
Thank you, commissioners.
Is that all for today, Chief Tracy?
That's all from sports wagering. Thank you.
All right. With that, commissioners, we are going to turn it over to item number 8, and we have, I believe, Director Monahan as well as Kara O'Brien.
Yes, good afternoon. I'm going to turn this right over to Chief of our Licensing Division, Kara.
Thank you. Thank you, Caitlin. Good afternoon, Chair and Commissioners. We are approaching the renewal period for the temporary Category 3 sports wagering operator licenses. And I wanted to take a moment to clarify the process as it will be slightly different from last year, given the regulation changes earlier this year. The process is more fully outlined in your packet starting at page 109. But in short, the regulations call for a two-step process. First, a temporary sports wagering operator licensee must submit a timely request for leave to renew their license, accompanied by a non-refundable renewal application fee. The commission may then grant or deny that leave. Then, as a second step, if the commission has granted leave, the licensee may request the actual temporary license. This request is accompanied by the next $1 million license fee. Once the commission approves the license request, the license would be renewed. Last year, this process proceeded in one phase, although each step was functionally completed, including verification of the application fee, license fee, and the commissioner's consideration and approval of the renewal. Because the process happened in one phase last year, only one form was approved. Before you today are two forms, which will accomplish the two-phase process as contemplated by the regulations. As these forms need to be approved by the commission, they are before you today for your consideration, and I'm happy to take any questions.
Thank you, Chief O'Brien. I I'm going to turn it to our commissioner expert, Commissioner Skinner. I see your mic's off.
Thank you. Good afternoon, Chief O'Brien. Can you remind me, either you or Director Monahan, why we ended up with a two-phase process? And so I guess my more direct question is, why would a licensee have to apply for leave to apply to renew, rather than just going straight to the application to renew?
Sure. So essentially, part of what the commission had anticipated too is essentially a check-in for certain, if we got to the third renewal, right? And essentially having an associated process along with that in which the IEB would provide an update and things of that nature. So it essentially needs to be a two-phase process to accommodate both that initial leave and associated IEB report consideration on the third renewal, and then also the actual request for the license.
One more time.
Sure. So under the request for leave section, that's where we get into if it's the first, second, fourth, or fifth renewal. It's an abbreviated process. It's designed to be, relatively quick. Whereas in the third renewal and the sixth renewal, there would need to be check-ins with the licensee, an update from the IEB, and that sort of thing. So that's a separate process from the actual granting of the renewal of the renewed license. It's essentially the application, the renewal application, so to speak.
Okay, we can talk offline because I'm still not understanding why we have to, aside from the fact that it's in our regulations, right? I'm just trying to recall the logic in in the regulation that we promulgated is all. So I'm sure there's a perfectly reasonable explanation. It's not sticking with me at the moment. So thank you for that. In what scenario would we deny a request for leave to apply to renew?
I believe that would be up to the commission. Obviously, if there were items that a particular licensee was not complying with the jurisdiction of the commission, again, essentially, it's a check-in.
The other thing I just might add is that it separates paying the fee for application versus the $1 million actual registration fee. And so it might have been, and we can go back and watch the videotape as it were, it might have been that they wanted to separate that out so you don't have to submit $1 million before you basically know that you're qualified.
Yeah, and to me, that seems like the only distinction, right? There is the application fee, and you might be right. But yeah, we can talk offline and figure that out for me. What is the fee, by the way, the application fee?
So it depends on the number of the renewal. The second renewal, which is this year, is $10,000.
Okay. All right, and then I have a question about the form itself once we get to that point.
Commissioner O'Brien, I see your mic's off.
No, I was just gonna supplement what Kara said in terms of if there was a contemplation also, Nikki said that, Commissioner Skinner, that if they for some reason weren't complying and the reason they had to ask to extend the temp status was because they weren't complying with IEB, we were also trying to figure out a way to make that distinction too. So kind of two reasons for it.
Okay, thank you.
It did seem a little cumbersome to my eyes, so I was glad that Commissioner Skinner asked the question. But I also know there's a reason. for most of what we do around here. So
It's in our regs, so there has to be a reason. I just wasn't recalling it. I do have just a notation for the form if we want to move there. Just the second one, the request for a temporary license to conduct sports wagering. It references in the applicant information section, it references 205 CMR 218.011A, which does not exist as far as I could tell. I did look on the website, the index of regulations. I also looked on Westlaw. I could not find that citation. So just double check that with legal, I guess.
I'd be happy to do that. And I do believe it may be a typo in it's 219.
So 205 CMR 219.011A.
Yeah, so this essentially this section of the eligibility comes from 219. And essentially it outlines if the licensee was originally found suitable by the preliminarily suitable, which is the 218, if the commission has awarded it a sports wagering license under durable suitability, or it has leave to request the temporary license. But I'll certainly check that and make sure to have that correct on the form.
Okay. Anything else, commissioners?
Well, 219.011A doesn't exist either.
Yep. So I believe it should be the actual citation is 218.07 is the correction. 1A.
Okay, sorry. So it's 218.
Yes, so 205 CMR 218.07 1A is the preliminary suitability.
Okay.
Let me ask this, Commissioner Skinner. Would you be more comfortable if we move to item number 9 and move back to this at some point?
Your call. I have it up right now. I'm just reading it. If you give me 2 seconds. Okay, yeah. Why don't we do that? Why don't we move to the next item? Sorry, and come back to this one, if you don't mind.
Is that okay, Chief O'Brien? And
certainly.
All right, so let's do that. That helps. Give you just a second to make those alterations. All right, with that, we'll turn back to that item. Is that okay, commissioners? All right. Let's turn to item number 9, and for that, we will go to Chief of Community Affairs, Joe Delaney, who I know has an issue for us today. Hi, Joe.
Good afternoon. Thank you, Chair and Commissioners. So today, what we are requesting is a transfer of some community mitigation funds that we granted to the Department of Conservation and Recreation, and we're asking to transfer those funds over to the Massachusetts Department of Transportation. And this is to complete the design and permitting of the proposed Mystic River bicycle and pedestrian bridge. And the amount of the transfer is proposed at $473,906.37. And where we got to that number was just a little background. Back in 2021, the Commonwealth unveiled a plan for the construction of this bridge and appropriated $49 million towards that construction. As part of that plan, the commission agreed to provide DCR with $650,000 of funding to complete the design and permitting of the bridge. So DCR started moving forward with the design and ran into some difficulties, primarily with the cost and the constructability of the bridge. As they explained that it was a complicated design, and there's only a couple of firms in the world that could fabricate such a bridge, and the cost would be significantly above what was appropriated. So DCR approached MassDOT to help them out with this review of this design, and it was determined that it really would require a redesign. And in addition to that, while Encore was going through the environmental permitting process for the east of Broadway development, there were a lot of folks who came out requesting that when this bridge is built, that it be built wider than what had originally been proposed. So that was another piece of the considerations here. So anyways, they had a number of discussions, and it was determined that it would be better for MassDOT to be the agency to design and build this bridge rather than DCR. So we talked with them quite a bit and agree that that does certainly make sense. MassDOT builds a lot of bridges, and they can probably do it more cost effectively than what DCR is doing at the moment. So actually right now, DCR is in the process of transferring the $49 million over to MassDOT, and is asking that we transfer this grant to them as well so that they can complete the design. They are eligible, MassDOT is eligible under 23K. 23K does say that regional transportation agencies would be eligible as long as it's work being done sort of on behalf of communities that are impacted by the casino. And of course, this goes from Everett over to Somerville, both communities that are impacted. So they would definitely be eligible. We don't have a final schedule from MassDOT yet. We will get one before when we put together the documents, the grant documents. But early on, they said they're looking at looking at alternatives starting now, and having that evaluation done by springtime, early spring. They're hoping, and then they will pick an option and advance that design to final design. And they expect to have a public hearing with interested groups, probably over the summer, maybe late summer. So that's where we are. So we are recommending doing this in that amount of $473,906.37, which is what remains from the original $650,000 grant. And I did include another memo that gives you a lot more history on this. This project really goes back all the way back to about 2016, when the Encore project was under construction. So there is a lot of background there. I won't go into the entire history lesson here.
Thank you, Chief Delaney. Commissioners may go into the history lesson. We'll find out. Commissioner O'Brien?
So Joe, my only question is there anything that procedurally we need to do differently than just asking to move it? Because I know that they are under the statute an eligible entity, but since they didn't actually apply, are we creating any problems for ourselves? And we just had a whole conversation about not bending the rules, right? So I just want to make sure we're not doing anything that's going to create.
I don't think we are. We will get an application form from them, basically that tells us who the contacts are and so on and so forth. But essentially, that's what DCR did when the money was transferred to DCR. So it's the same project. It's the same scope of work. It's the same everything. So really that just kind of transfers over.
It's not, I'm trying to conceptualize it so it's not missing an application that was timely filed. It's more just almost the project manager's changing as opposed to the actual entity,
That's fair. It's just that, being a separate agency, we have to do a separate ISA and so on.
Yeah. So as long, I don't know, Todd, if you guys are also, you're kind of thumbs up with it too, in terms of, because obviously they didn't submit an application, right? And we've been pretty strict on that deadline. So just want to make sure that this transfer is not running afoul of anything like that. I'm supporting it. I'm not trying to stand in the way of it. I think it's a great idea. I just trying to make sure we're not setting ourselves up for anything.
I have not looked at this, so I can't answer that right now, but I will look at it.
Okay.
Yeah, as I said, we could just simply request an application form from MassDOT. And, if we.
Yeah,
get that-
my only concern is we have that deadline, so I'd hate to say on a one-off, well, we'll just let you put it in late.
Well, no,
So,
they're putting it in early.
so this
I
is
mean,
for
our
next year then. So
Yeah,
this is an
our deadline
anticipation.
is, our deadline is for
February, right?
applications is January 31st, so it could
But
fall,
this was-
although it's using previous year's money. So.
Yeah, I guess that's what I'm trying to, is this like a new,
Well, actually, it would be a
allocation
new-
for
it would be-
25, or are we repurposing a pass? That's just the line I'm trying to make sure we don't
Yeah,
blur.
what we would be doing on this is actually canceling the old grant and writing a new grant to MassDOT.
So this is really a 2025 grant.
Yeah,
Yeah, I mean, that's like I said, I think it's a great idea. I think we should do it. I just want to make sure we're doing it in a way that is consistent with how we treated anybody else, or we always say, well, how we're going to vote is going to depend on how much money, how many people ask for money in 2025, et cetera. So,
well, and this is money that's.
how do we
already
do
been-
this as cleanly as possible? Is my question.
Joe, just to jump in, I will say that we have historically moved funding from other grants in a similar situation where a different community has decided to manage a project. So it's not precedent setting on our side. And kind of like Joe said, it's just about cutting a different ISA.
Right. So I guess the answer would be, it's probably best not to do. Have you done applications in the past? I know we voted to say they're going to repurpose monies and distribute it out to somebody else. And you're, as opposed to like, we're handing off this, it's a big chunk of money.
Yeah. I think, when we put this over to DCR, I think we did get an application from them. We said, it was sort of a truncated application because.
Yeah.
We knew what the project was and, we had a scope of work and so on. But yeah, I think, we could just certainly do that, get an application from them.
However you did it the last time. Yeah.
Yep.
Just,
okay.
I think we need to be consistent, right?
Yep.
Yeah, we did that with Holyoke Community College and STIC this last year when our finance team asked us to do the contract slightly differently. So Holyoke Community College came in and submitted an application, but then when it came to the time of cutting out the contracts, we actually had STIC come in with a different application. They kind of resubmitted a very similar application. They took out their chunks of HCC's application. So
was that filed timely or finally after the deadline?
So the project was filed timely, but the change of the contract was to a different agency. But
the different agency application was after the deadline, right?
Yeah. So, but I would say that the DCR project was filed at the time timely.
Right. No, I get that. I'm just saying, like, however we've handled it, I want to be consistent, but I also want to make sure that letting somebody come in and file an application, we might want to call it something else because that's not really what it is. It's
Right.
just getting all the necessary info in order to basically do like an assignment of a project, right? Like taking over, which is a little bit different. I just want to do it in a way that nobody comes in later, right, in March and says, well, I want to take that money. They're not using it. And, I know I missed my application deadline, but you've taken late applications in other circumstances.
Well, this is really at the request of the applicant.
Right.
I ask a question, the difference here, so is it that the DCR grant contract has expired? Is that what the concern is here?
No, it's just the ability, having the manpower to get it done. MassDOT does bridges all the time and.
In terms of Commissioner O'Brien's question about, the deadline and whether this is actually a new application, I guess that's what I'm trying to understand. Is the 2021 monies, were they required to have been spent by a date certain under the terms of the grant contract? And is that therefore why we're concerned about transferring in this way to MassDOT?
No, that has nothing, it has nothing to do with it. The date, the expiration date of the contract. I mean, if the contract expired and DCR wanted to continue on with it, we would give them an extension on the contract, or on the ISA. In this
Right,
case, it
right,
does,
right, yeah, so that's why I'm asking what, I guess my question is to Commissioner O'Brien, is just what is, if that's how we've done it, what's the concern? And that's a legitimate question, just to understand.
Commissioner
For
Steele,
me?
do you ever ask illegitimate questions? Let me get that.
No,
I
because
don't feel that
I mean,
constraint.
I'm thinking it's a good point, but I just want to make sure I understand it.
Yeah, so I mean, my memory has been we've repurposed grants, right? So it's almost like I was going to go out and distribute this monies, but I'm actually going to take this amount. I told you it was going to be administrative costs, and I'm putting it into the culinary program, that sort of thing. But the whole cloth, I'm going to step out. We're assigning this project to another entity to finish executing. I just want to make sure how we've been doing it and conceptualizing it. I don't love the idea of a new application, because it's not a new application. It's basically an assignment of the benefits, right, of that contract. So I just want to make sure that we're doing it in a way that does not create sort of the late filing of an application, because we don't allow that.
Yeah, I do think it's a different situation for this one particularly. It's not, as you mentioned it, these are 2021 funds and they have actually spent against the grant. Just as the process has moved down the line, like Joe said, MassDOT really great at building bridges. DCR really wanted to move it over to them so that they had a little bit more flexibility with how they're moving the project along. There's just a lot more resources over there to do this kind of project. So, we've obviously, our team has been meeting internally. Mary's been doing an awesome job keeping on top of DCR and, meeting regularly with them to make sure that the project is actually progressing. And after all these meetings, we've kind of worked with them to understand how do we actually get the project to come to fruition. And this is where, after months of meeting on it, where everyone landed.
Isn't this roughly akin to DCR hiring MassDOT to execute?
Yes.
more or less.
Right. That's what I mean, like taking over as the project manager or the contract team or the construction.
Yeah, it's almost like subcontracting it out, but it's cleaner. And John can also speak to this, John Scully. It's a lot cleaner on everyone's end to
if
send the
DCR.
money. Yeah, to have DCR back off.
Well, this is at DCR's request. They were awarded the funds. The scope is still the same. DCR has done some of the work. MassDOT is the expert in this field. And since they are another state agency, we can transfer the ISA over to them with the same scope.
Right. So it is a little bit different in terms of if you were switching the type of entity too.
Correct.
Can I get a little bit of the history lesson? Because my memory from way back is that this pedestrian access was almost part of Encore's original proposal as part of their, conceptual designs and all that jazz. Is that not the case?
Not exactly. It started out with Encore is required to do a study as part of the environmental permitting. They weren't going to make them build a bridge, but they said, we want you to at least do a feasibility study. And when they started looking at it, they said, there's really only one place that it can go. So can we not do this feasibility study and just start moving it towards design? And the answer then was yes, sure, because it made sense for where it was going to go. And there was a lot of constraints with the bridges and so on. And then at that point, Encore said, well, we're going to take this thing all the way to design and we're going to build it. And then the pandemic hit and they sort of reevaluated the costs and so on and said, well, we're not going to do this. And it had then dropped. And that was when in 2021, when the governor agreed to put up some money towards this project and said, let's get it built. And he asked us, the governor asked us to pony in some money towards that project, which was the design funds.
No, I just the promise of those improvements to both communities taking so much time to get implemented and get off the ground is incredibly frustrating to me. I know it's frustrating to the communities, to multimodal transportation activists, frustrated that at some level with Encore for not being fully committed to implementation as far as far as I can tell. Doesn't sound like they're under a legal obligation to move forward, but I think it was, it's disappointing, and I'm glad we're taking this step forward to get MassDOT on it and to hopefully move this towards completion.
Yeah, that's all our hope. When we went to the public hearing on the bridge, I never saw a group of people that were more in agreement of something that should be done.
Yeah, it's not for lack of trying. I mean, I can say that as someone who's been around for a while on anybody's part.
Oh, I have no doubt about that.
And I remember EEA being a part of this. I imagine that's where the DCR piece kicked in. And there was a trails grant, and I remember being in a room talking about this in 2021. And so we'll be happy to see that bridge. I'm sure it's going to help. I support it. I support the move. I do have questions. I supported Commissioner O'Brien's questions. I jotted one down. Just what's the process for repurposing a grant to a new entity? So maybe that's for a different time. We can have that conversation. Just if you educate us. And Lily picked up exactly on my question about. I remembered us doing this in the past similarly. So thank you, Lily, for that. Commissioners, anything else? Do we have a motion?
I move that the commission approve the transfer of funds granted to the Department of Conservation and Recreation in the amount of $473,906.37 to the Department of Transportation to complete the design and permitting of the Mystic River Bicycle Pedestrian Bridge as described in the commissioner's packet and discussed here today, and further that commission staff be authorized to execute all necessary grant instruments commemorating this grant in accordance with 205 CMR 153.04.
Second.
Thank you. I think Commissioner Broder got that one.
I'm sorry, Mr. Chairman.
Yes.
I'm sorry. Is Commissioner O'Brien all set? I know she had.
I'm good.
Okay,
I'm good.
sorry.
Yeah. No, thanks for asking.
All right. We do take roll call votes, so we would have learned that quick. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes 5-0.
Thank you.
Like a bridge over troubled waters, Joe. Thank you. All right. Can we now return, if the commissioners don't mind, to item number 8?
Chair has everything figured out for you, so I'm going to turn it back over to him.
So yes, essentially the citation is a typo. So the second form, the citations should be 205 CMR 218.071A.
Commissioner Skinner, are we good with that?
Yes, I did have the opportunity to read it and I'm good. Thank you.
Commissioners, any other questions or comments on these forms? I'll say they're succinct. They look really easy to fill out.
We try to make them straightforward.
Perfect.
Mr. Chairman,
Commissioner Hill.
I'm going to ask my fellow commissioners, I can actually do both of these in one motion, or would you like to do them separately?
You moved and we'll vote.
Okay. Then, Mr. Chairman, I move that the commission approve the form for request for leave to review a temporary license to conduct sports wagering as included in the commissioner's packet and discussed here today, and further move that the commission approve the form for request for a temporary license to conduct sports wagering as included in the commissioners packet and discussed here today.
Second.
Second.
All right. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes, 5-0. Is that all you have, Chief O'Brien?
That's all I have for today. Thank you.
Thank you. Director Monahan, we all set?
All set, thank you.
All right, thank you. With that, commissioners, we do have some executive session minutes. If you would prefer, I can go ahead and we can take 11 and 12 out of order, so then we can end our meeting with the executive session. Do we have any commissioner updates? All right. Any other business? All right. With that, let's return to item number 10. I'll read some language into the record. The commission anticipates that it will meet in executive session to review minutes from previous executive session, as the discussion at an open meeting may frustrate the intended purpose for which the executive session was convened, pursuant to General Law, Chapter 30A, Section 21A4, Chapter 30A, Section 21A7, and General Law, Chapter 4, Section 726F, November 21st, 2024, and General Law, Chapter 30A, Section 21A7, General Law, Chapter 23N, Section 6I, and General Law, Chapter 4, Section 726N, January 11th, 2023. Do we have a motion to enter an executive session?
So moved.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
I vote yes. So we will not be returning. We hope everyone has a great Monday and a great holiday season. Have a good day.